Good morning. Thank you for joining us today. This morning we'll be talking about effective criminal case management. You'll learn about what predicts and what does not predict timeliness in criminal cases based on the results of the largest study of criminal case processing to date, Effective Criminal Case Management, or ECCM project, funded by Arnold Ventures and conducted by the National Center for State Courts. You'll also hear from two experienced trial court administrators from different parts of the country with different court and community backgrounds, and they'll talk to us about their experiences and key principles for effective practice in real court settings. Today we'll be talking again about effective criminal case management, which we can kind of think of as talking about two sides of one coin. So we'll be looking at what the data tells us from the ECCM project and looking more at predictors of efficiency or timeliness. So these data findings will illuminate important national patterns in both felony and misdemeanor caseloads. And we'll also examine factors that explain the wide variation we see in timeliness across state courts. This might help courts to think about specific targets for overcoming barriers and delay in their own criminal case processing. We'll also look at another side of the coin, which is what practice has taught us, looking at effective strategies for case flow management in criminal courts. Again, we'll hear from two practitioners, both from high-performing criminal courts. They'll give us their perspectives on case management barriers and effective strategies to overcome those barriers, including their court's experience during the pandemic and how we might move forward from here. First, I'd like to introduce our speakers before we get started. I'm Lydia Hamblin. As I said, I'm a Senior Court Research Associate at the National Center for State Courts. We also have Ed Wells, who's a court manager for Harris County Office of Court Management. Paul Silverman is the trial court administrator of the 8th Judicial Circuit Court of Florida. That's in Gainesville. Ed's in Houston, Texas. And Brian Ostrom is a principal court research consultant for the National Center for State Courts, and he's also the principal investigator for the ECCM project. First, we'll hear from Dr. Brian Ostrom, again, the principal investigator of the ECCM project. He's going to describe the study and the major findings. Brian?
Thanks, Lydia. Yeah, ECCM was designed to discover effective practices in the state courts for resolving felony and misdemeanor cases. As Lydia noted, this is the largest study of its kind ever undertaken. And we began that process by gathering information that would allow us to understand from an empirical side what determines timeliness in case processing. We gathered information on over 1.2 million felony and misdemeanor cases. We had 136 courts in 21 states involved. A big part of the project for the ECCM staff at the NCSC was to analyze that data to determine the factors that most directly shape criminal case processing. In doing that, we looked at a wide range of factors, including court structure, for example, whether the court is a single tier or two-tier court system, court organization, for example, type of calendar used by the judges, and case characteristics, for example, like the severity of the charge or the manner of disposition or the number of continuances, to determine how these factors influence case processing time. The results indicate that court structure and court organization have minimal impact on timeliness. What we found was that court case flow management practices are the key to timely case outcomes. And so that led us into our second phase, where we worked with 8 courts that do a great job of managing criminal caseloads. And we're fortunate to have Paul and Ed with us from 2 of those courts. You can see here on the right of this slide that in our work with those 8 courts, we identified 5 key elements to successful criminal case management that will be a big part of our conversation a little bit later in the session. But first, I want to just show a little bit of what we learned from the data collection. And in doing that, just to start with, why are we concerned about criminal case management? Because it's a big deal. The ECCM allowed us to come up with an estimate of how many criminal cases are being handled in state courts. You can see there's over 18 million criminal cases resolved in the state courts each year. 5 million felonies, 13 million misdemeanors. And to put those numbers in a little bit of perspective, that 5 million felonies means that there are 40 felonies being resolved every minute of every day in the state courts, and over 100 misdemeanors. So the people on this, watching this session, you know firsthand that criminal caseloads are large, they're growing, and they are a critical part of effective management. So the one of the things I want to focus on for just real briefly are issues related to backlog. And what is backlog? That refers to cases that are pending beyond a reasonable time frame. And what's a reasonable time frame? Well, those are typically determined by time standards. Most every state has adopted time standards, and many of them have gone with the model time standards that you can see over there on the left. And those model time standards suggest that 98% of felony cases should be resolved within a year, and 98% of misdemeanor cases should be resolved within 180 days. And with that combination of time with a standard, model time standard, sets a benchmark. And so it says that if you have more than 2% of your felony cases pending beyond a year, or 2% of your misdemeanors beyond 180 days, starting to develop a backlog. What we learned from ECCM, though, is that no court in the country currently meets those time standards. Some come pretty close, but we can see here that the average around all of the courts involved in our study show that on average 83% of felonies are resolved within a year, and 77% of misdemeanors within 180 days. So that suggests backlog's a reality for most courts in our country today. To take a little bit closer look at some of the drivers of timely case processing, what we see here is an example of a more timely court on the left and a less timely court on the right. And so if you look at that more timely court, what you'll notice in that distribution is that there is a peak in that distribution early in the life cycle. And what this is showing us here is that the age at which felony cases are resolved. And go to this next one here. This indicates why one court is able to get more close to the model time standard recommendation of over 90% in 365 days, while another is less than 80%, is that early court intervention in the case, continuous court control. More timely courts pay attention to cases throughout their life cycle, beginning at the very start, identifying cases that are good candidates for early resolution, that they can be resolved in a fair and timely way. Those being identified and resolved then gives the court more time to pay attention to the ones that really need that time. In slower courts, like the one on the right, every case gets essentially treated the same. And so you don't see a peak in that distribution. In fact, the distribution is quite flat as cases are resolved at varying points, but they tend to be older, and you can see that backlog is without that attention to that early intervention and continuous court control. So what came out of our study about some of the main findings of what does and does not account for differences in timeliness? What we found was that there is really no difference in the composition of caseloads or the manner in which cases are resolved for both felony and misdemeanor cases in courts throughout the country. So every court is handling essentially the same caseload. It's just that some courts are consistently able to resolve that same caseload in tighter time frames. And what allows faster courts to achieve that status? The primary drivers of case processing time are the number of continuances per case and the number of hearings per case. So it didn't have anything to do with court structure or organizational factors like the type of calendar that the judges use. It focused on case management practices. More timely courts are able to employ those good principles of case flow management to maintain control over scheduling, reduce the number of continuances, and have just the right number of hearings that it takes to effectively resolve criminal cases. So what this comes down to is timeliness is determined by court policies and practices. Every court can achieve timely case processing by paying attention to key principles of effective case management. And what works in successful courts can easily be transferred to other courts around the country that have an interest in achieving timely case processing. And so what we want to do for the rest of our session today is to talk with Ed and Paul about some of the strategies that they use in their courts to achieve timely case processing. Lydia?
Thanks, Brian. We now like to bring in Ed and Paul, our two practicing experts in the field. We've had some really great conversations with them, both during the ECCM project and other projects, and more recently while planning for this session about the court, the pandemic, and just in general around case flow process and case flow management for criminal cases. So Ed and Paul, thank you for joining us today.
Thank you for having us.
Absolutely.
So first, why don't you tell us a little bit more about your court? So example, the types of cases heard, the size of the bench, the criminal court specifically, and more about your community, and also how long you've been with the state courts.
Okay. Thank you, Lydia. I'm the trial court administrator for the 8th Judicial Circuit in the state of Florida. We are a small, primarily rural circuit in North Florida, sit between Jacksonville and Orlando. Beginning at the Florida-Georgia border, travel south about 75 miles, and then west 75 miles to the Gulf of Mexico. And that's what our circuit looks like. So when I say we are small, it's small population-wise, not small geographically. We're about the same size as the state of Connecticut in our circuit, but we have about 400,000 people, where I think Connecticut probably has about 4 million people. Yeah. We have that small number of people is reflected in our number of judges. We have 13 circuit judges for the entire circuit. It covers 6 counties. Only 4 of those circuit judges handle criminal cases, circuit-wide. So they travel throughout the circuit to hear their criminal cases. We have an additional 10 county judges that hear criminal cases as well. Our circuit is headquartered in Gainesville, which is the home of the University of Florida. Although we have a relatively small permanent population, that number increases by about 75 to 100,000 when school begins. Not during COVID, but normally. Not only the University of Florida, we have a very large community college as well. And that has an impact, needless to say, on our courts and our criminal proceedings as well. Those judges cover each of those things. Outside the University of Florida, not only is it extremely rural, but it's also fiscally constrained. Those counties do not have very much money coming in, and that impacts the resources we have and our ability to address these cases.
Okay. Ed Wells, I'm court manager for the Harris County Courts at Law in Houston. We have a large jurisdiction here. Harris County has 4.6 million people. We have 16 county criminal courts at law that hear misdemeanor cases in which punishment can go up to 1 year in jail. We have 22 felony district courts that hear all felony cases in Harris County. And then additionally, we have 16 justice courts that hear fine-only criminal cases. My office is responsible for all of the county level courts. That includes the misdemeanor courts, both fine-only and with jailable offenses. The fine-only cases total about 400,000 cases per year. The Class A and B misdemeanors total about 55,000 a year. They've been as high as 80,000 in given years, but they've come down the last few. We also have 10 magistrates who handle all findings of probable cause, magistration, and initial bail hearings. Our courts also have had the added burden for the last several years, post-Hurricane Harvey, of being displaced from our courthouse. We only recently got all 38 misdemeanor and felony courts back into the courthouse, but with very limited capacity. There's ongoing construction still in our courthouse. And of course, we all have the constraints of COVID to deal with as well. So it's been very challenging, and we do have backlogs in both court divisions where we did not have that, certainly as large a few years ago. But we're working through that, and we're learning a lot. And you know, as Brian talked about with regard to the principles, it's getting back to the basics. So I really look forward to having this conversation.
Great, thank you. So my first question, what are some key principles or practices you find most effective for managing the criminal caseloads in your own court? And are some of those principles emphasized more or less during the pandemic?
Well, I would say consistent with what Brian found in his study, early intervention is number one. And early evaluation, I would say, is probably the best way to describe it. Our most successful divisions from a case management standpoint are ones where the judge, the prosecutor, the defense attorney are working together. They're evaluating, particularly the lawyers, evaluating the case right at the beginning. And the state is offering a plea negotiation at the beginning based on the evaluation of that case. And that plea negotiation will most likely get worse or more tougher for the defendant as you get closer to trial rather than better. You know, I think there was in the old days, there was a style where you went right, it was brinksmanship, you went right to trial, and then the deal was best the morning of trial. And that is not an effective way to case manage. It requires the attorneys to do work at the beginning. They've got to evaluate the case as best as they can and make that deal the best deal can. Now that the deal can change, of course, based on circumstances. We all know that witnesses can disappear, change their mind. There can be, but the run-of-the-mill, straightforward case should be evaluated early. And we have quite a few pleas at arraignment and at our very first case management conference. And in part, the judges can impact that by, although they don't have control over a plea negotiation as it relates to the charge, they do have some control or impact on the sentencing. So, you know, almost always our judges, if there is a recommended sentence early in the case, they will almost always abide by that. You know, some exceptions based on the circumstances. But as the case gets closer to trial, it becomes an open plea. One where it really does not matter what the state is recommending. The judge is going to sentence as they see fit. And that's a strong incentive to address the case early and get it resolved. The other thing I would say, number two, or maybe 1A, would be the setting of trials. It is human nature, I think, not only in the criminal realm, but in every realm. Cases that those that don't get resolved very early, like I referred to, if they move on to the next stage, you've got to have a credible trial date in order for people to resolve the case. One method that we've used, because we have so few criminal judges, say we have 4 judges doing all the felonies, 13 circuit judges overall. So we work as a team, and any trial that's set, we never continue it because we will not have a judge available to try it. If the judge in that particular division is maxed out as far as his trials, we'll get someone else as a judge somewhere, whether it's a circuit judge or a county judge acting as a circuit judge. We'll get someone to try the case. The result of that is that the cases often don't get tried. Just the fact that there is a judge there ready to go, ready to impanel the jury, often results in a resolution of the case. I'll give you a great example of that. We've started, and we'll talk more about jury trials and COVID a little bit later, but we've started to do jury trials again here. In the last month, we've had 30 cases on the trial docket ready to go, and 28 have resolved that one, because we were ready to go with a trial, and I think that's common. That's really indicative. I'll let Ed pick it up from there.
Well, it's kind of the same things. That early control or court intervention becomes very important, even more so today. The reality is that criminal cases have become more complex. There's more discovery that has to be done, collected, reviewed, shared, all of those things. And courts being very involved in the scheduling process early, setting real consistent, good expectations helps move cases. There's always going to be the exception. And absolutely, courts need to recognize the exception and treat them differently, but we don't need to treat the majority of cases as if they're exceptions. And I think by recognizing that and being consistent with it, that's one of the ways that courts can move cases more timely. Again, when I say move cases, it's helping a case progress toward disposition, ultimately preparing it for trial. But as we all know, it's something close to 1% of criminal cases that get disposed of by an actual trial. And so learning more about that case, the early screening that Paul was talking about, then making a reasonable offer from the state and moving that case forward. But you can't do that without the evidence being collected, without some idea of what both sides are bringing with regard to trial. And so it takes a little bit of work. And again, it's up to the court to help keep that on schedule. I think that's the biggest thing I see, encouraging conversation between the prosecution and defense on a regular basis, but keeping those timelines out there in front, very visible to people, and reminding them that they're there and reminding them when they don't meet a timeline. That's really what sets, when I look at courts and see some that move cases faster than others, have smaller caseloads, it's because the court is very involved in that process, and the people who come before the court recognize that and they follow suit.
Lydia, the second part of your question was what impact the pandemic has had on these principles that we haven't yet addressed, and it's been very interesting, really, in addressing that. And one of the things along the lines of you need to have a credible trial date in order to move cases. We've done something here that you could call it disingenuous or you could call it clever. I'll leave that up to the audience. But we have not said no trials for 6 months. We haven't done anything like that. We have told everybody that it's a month-to-month decision. We review the data. Our chief judge has made the determination, I think, probably like most chief judges, we're not going to do a jury trial until it's safe to do it. That's the guiding principle. But we don't know when that is. So, when we shut things down in March, there was some pressure to say, okay, nothing's going to happen until at least October. But we knew if we did that, nothing would happen at least till October. And when October came, we were ready to try cases. The cases would not be ready to go. So we have literally said it's a month-to-month decision. Once a month, the judge makes a decision, chief judge does, as to whether there'll be a trial the following month. So although it's likely that it wasn't going to happen, there was something in the back of the mind of both the prosecutor and the defense attorney, knowing that it was possible. So they moved the cases so they were close to being tried. And I think that was really critical for us moving cases. We don't have a tremendous backlog right now. We've really been able to resolve the cases. The backlog that we've got are the most critical cases, the most difficult, the most serious cases that we haven't been able to try. There are some cases that just have to go to trial. They can't be resolved otherwise. So that's been a little trick that we did. One other thing that we've had to do during the pandemic is the judges have had to stay on top of the case as it relates to discovery. I know this doesn't apply in every state where there's not. We have very liberal discovery in Florida, and it's very easy for the attorneys to come to the case management conference and say, I haven't been able to do discovery because of COVID. Well, if the judge knows the case and it's a simple case, there's one witness, they can get involved in that point and take some action and say, well, what do you need to do to speak to this one witness? So those are the slight changes that we've had to make during COVID in order to get the cases or allow the cases to continue to move.
Yeah, unlike Paul's situation in Texas, the Texas Supreme Court came out and did stay trials for month to month largely, but there wasn't the possibility of trials because we couldn't assemble jurors. And so that had kind of the opposite effect. People were requesting jury trials because they knew we couldn't give them one. And so that did create an increase in the number of cases set for trial that pushed things off for many months. We're to the place now in Harris County where we're starting to have jury trials again. We've had a handful scheduled. Much like Paul, you see cases go away once they're facing that. Looking forward to next month when we have significantly more cases set. But again, getting back to the extra difficulties we've had here, we not only had an impact to our courthouse, but we had an impact to our jury assembly space as well. So we're having to do that offsite in another facility with limited capacity for that, which is impacting all courts. There's 100 trial courts in Harris County. And so we're having to share with everyone following statutory priority, other things. But that's been a very difficult thing for us. And we're looking forward to getting back to the place where we can have credible trial dates and actually hold jury trials.
Well, you're both already ahead of me on the next question. You talked a little bit about this, but I know we had a pretty interesting conversation the other day, so I'd love to hear your thoughts again, just about trials in general. So we've heard a lot of discussions in the state court community about what criminal courts are doing for trial, both bench trial and jury trial, and some issues they're discussing, not just with the court, but with other justice partners or with other points in the process, such as discovery or communication between defense counsel and the defendant, and creative space solutions. Could you all talk a little bit more specifically about what you're doing or you're planning to do around these different issues for trials?
Sure. The jury trials in the COVID era is very labor intensive. They have to happen, as we mentioned before. Without them, we're not going anywhere. Not to even aside from the case management standpoint, there's a constitutional requirement that we do so. Although our Supreme Court has told the speedy trial rules, as they probably are in most states, we still have an obligation. There are people in jail that would like a trial, and we need to provide them a trial if there's any way we possibly can. But it's tough. We've spent the last several decades figuring out the most efficient way to do jury trials. And that is all out the window. We would, and I think probably most courts, we'd bring in a large number of people on Monday morning and put them all in one space and separate them out to pick juries. We would qualify them, and you do start several jury selections all that day. We cannot do that now. We cannot bring in large number of people in one space. So we've taken the position. Our policy now is one jury, one trial. They're all what we call pick and goes. We were only bringing in the people, enough people to select one jury at a time. More may come in that afternoon or the following day, but we've got jury selections going on at various times throughout the week. Highly inefficient, but the only thing that we can do in order to allow this to happen. And then, we feel we're concerned about jurors coming in. I mean, we're concerned about everybody, but everybody else in the system has got a stake in the game. The attorneys, this is their job. The judge, the clerks, the litigants are there. They're involved, obviously, in the case. Jurors are not. They've got no stake in this game. We're asking them to come in and hear this, and really everything that science tells us, this is possibly the worst case scenario. We've got people together in one room for a long period of time. And most courthouses are probably like ours. The ventilation is not great. Nobody's got the funds to change that. So it's a difficult situation. So we are extremely careful. Everybody's got to wear a mask all the time, which raises other issues, potential due process issues with witnesses and jurors wearing masks, but we require it. They have to be distanced. So we've had to do some creative things related to where we do the trials. We're doing them in our courthouse, but we're not using jury box. We're using the gallery, and that's where the jurors sit, in the gallery. That raises separate issues of maintaining the record during jury selection. We don't have microphones and for our digital recording process in the gallery, so we've had to work with that. That also keeps the public from being able to come in. You can't have the public come in that they normally would be allowed to when the jurors are in the gallery. Those are all issues that we've had to address, but we're working through it piece by piece to make sure that we can get it done.
Yeah, we're handling trials in a similar fashion. We do have courtroom space considerations that we have to take care of, but we're using the gallery right now for the jury box. I think in the misdemeanor courts that we will be able to accommodate with a 6-person jury use of the jury box, but we're going to have to be creative and utilize some of the plexiglass barriers. But other things, jury deliberation. Jury rooms were made for the size juries you had. And now with social distancing requirements, we may have to find additional spaces for jury deliberation. Like Paul mentioned, very limited, if any, space for the public to come in to view a trial. So we're having to live stream trials. We live stream courts every day because of that limited capacity in the courtroom. And that creates challenges, with all the new discovery. How do you present discovery in a virtual world, or how do you present it meaningfully to those who are coming in, even if they're not participating in the trial or the hearing? How are they understanding exactly what's presented? And so making sure that live stream experience is as good as it can be. There are limitations to it, without a doubt. And from March to today, we have learned a great deal about how to do it better, either through better technology, better process, things of that nature. But that's an ongoing issue. That's not going to go away. And so the issue of counsel and client communication to date, we've tried to handle that by having counsel and client together whenever possible, whether that's in the counsel's office, in the courtroom. If a defendant is in jail, that's a little more difficult, but we can accommodate that. But those are all things that we're learning to do differently, and recognizing there's no magic bullet in all this. We're going to have to be flexible. We're going to have to do some things that maybe don't work out, and then just stop that and go on and do something different, because we've got to keep the cases moving forward, because they're still coming in the front door.
Lydia, one other thing that may be helpful for those who have not yet started post-COVID jury trials, a couple things that we've found so far is that they simply take longer. One, you need to be prepared for it. Moving the jury in and out, even the defense counsel and the defendant speaking, they'll need more breaks when they need to have an opportunity to speak outside the presence of the jury and the court. Bench conferences where everybody would huddle together for just a few minutes. We don't want people to do that, because now you've got a lot of people together with a court reporter. So we're taking the jury out, or the judge and the lawyers are going to another spot. And so so far we're figuring about 50% longer a 2-day trial is going to take 3 days, most likely in the COVID era. The other thing we found is for us and really all the rest of the courts around the state of Florida that have done it, we've seen a fairly consistent jury summons yield. And that's the question I think a lot of people have. How many jurors do I need to summons in order to get a jury? And we're getting about 30% of the total number of summonses for people that are appearing. One thing that we've done here, and this is at the direction of the Supreme Court, is essentially jurors are allowed to opt out. We have a new jury summons where it pretty much says if you're uncomfortable in the COVID situation and you'd like to postpone your jury service, you can do so by checking here. The law in Florida still requires that a judge review that and consent to it. It can't be completely automatic, but for the most part it is. And what that does, it obviously reduces the yield, but the people that are appearing at the courthouse are ones that have already had the opportunity to opt out. We have not had very many people that have come and said they've got a problem with COVID issues. There are people that have considered it and are ready to serve. So that has helped. It helped reduce the number of people coming to the courthouse, which is what we wanted, and allowed us to pick a jury a little more quickly.
Well, thank you. So what are some system-wide factors that may contribute to timeliness or delay in criminal processing? For example, this might be communication between justice partners or certain community resources that are lacking or available in your community. And what are some insights or what you've learned about how to manage those factors? So kind of going beyond the judge and attorneys and locally your team in the courthouse and looking at the bigger system.
There are some things that are simply out of the control of the judges or court administrators, and despite your best efforts, you may not have success in case managing these criminal cases, or you might have success even if you're not doing exercising some of these principles, and some of those things are just simply the relationship between a particular judge, the prosecutors, and the defense attorneys in that division. How well they work together, how well they communicate. It's something that's difficult to impose someone. Sometimes it's just a personality issue and how they address their cases. Those units that work more cohesively tend to resolve their cases more quickly. That's one. The other thing is policing attitudes. That really changes things quite a bit, particularly in county court more than anything else. Who's being arrested, who's not, what's important to a particular sheriff or chief of police. We've had over the course of time sheriffs that have a big interest in traffic cases and some that don't have a big interest in traffic. And as everybody knows, traffic cases in county court could be a huge number. So that's very impactful as far as case management goes. Diversionary programs, state attorney or prosecutor's willingness to send people to diversionary programs have a big impact. We have a prosecutor right now that has a diversionary program that never even gets to the court, that it happens upon arrest. If the person consents to it, obviously, if they meet certain criteria, the case never even gets filed. It goes immediately to a diversionary program. If they comply, then the case is dropped. That has dropped our county court cases by about a third. So that has, and again, those are things that it just depends on who are in those secondary positions.
So very similar to that, diversionary programs have had a big impact in our courts. Even before the hemp versus marijuana question came to be, mm-hmm. Our prosecutors were diverting cases from the courts at arrest for small amounts of marijuana possession. And that reduced those filings by, a third, something like that. But there are other diversions that take place. People who have mental health issues being diverted to local services. Those who are have been in the past arrested for trespassing, things of that nature, those being handled differently and never being filed in the court. That's a part of that reduction in our case filings that I mentioned before, with these diversionary programs and other community services that have become more closely aligned with criminal justice. And so that's had a very positive impact on our ability to move cases timely. Some of the things that have detracted from that, we've talked a little bit about the complexity of cases, the amount of discovery involved in criminal cases today. And so one of the things that can help with that is for courts to devise systems to better track that, right? When we're screening a case early for complexity, having a good idea of what's going to be required to prepare this case for trial, and then actually tracking that and building those factors into our scheduling so that what's reasonable. Several years ago, it would take many months for us to get a blood test result in a DUI, DWI case. Today, that happens very timely. But today, video, particularly body cam video, and the large volume of video, you have patrol car video, body cam video, you may have surveillance video from multiple sources. That all has to be identified, gathered. Someone's got to review it on both sides of this case. That's time to do all of that. And as opposed to looking at this and saying, okay, it's going to take 90 days to get this video evidence, why does it take 90 days? Right? It's available somewhere. How can we expedite that? And while the court doesn't have direct control of that, the court can shine a light on it. And I think that's an appropriate role for the court, and then start partnering with other stakeholders to help improve that, because ultimately that's what's going to help us move the case more timely. And we should talk about that in terms of untimeliness having a detrimental impact on justice. Because too often people don't recognize the connection between the two. And so, again, that's one of those roles of courts in educating the others as to what it is we're trying to do and why. And when we're unable to do it as well as we should, what's the impact of it? And that impacts everyone. That impacts the defendant, impacts potential victims, and impacts society in general. And so making it easier to move cases timely through, again, that attention, monitoring things, reporting it to the stakeholders. I think those are all things that contribute to more timely disposition of cases.
Okay, thank you. So let's talk about data a little bit. What data do you, your team, or your court use for criminal case flow management? And are you collecting any new data during the pandemic?
Well, we look at things I think probably most do. Clearance rates, time to disposition is a critical element. I would not say that we're collecting new data here, but we're frankly during COVID, it has less credence to it because it's some of the things are so much out of the judge's control, where we normally dissuade them from granting continuances, or there has to be a really good reason for it. They have to loosen up on a continuance. I mean, because people have their own attorneys. The defendants have their own personal issues. If we have a lot of young attorneys and they have childcare issues and family members, and we have got to be sensitive to that. And I think that's critical. So the numbers are skewed some. I'd say my circuit is probably a little different from Ed's, because we are so small. I can eyeball some things. I don't need as much data probably. I can see if one of my 4 divisions is all I've got in my circuit is starting to bog down, and we can offer the judge some suggestions or offer them some services to help.
Yeah, and so data in our courts has been important for many years. We improve our ability to gather data and analyze it every day. With regard to the pandemic, we don't really collect new data, but we do look at it differently. We historically have always looked at active cases pending and a benchmark for that per court or per judge. But we also look at clearance rates, time to disposition, the number of settings to disposition, and a little more scrutiny on the time between settings. Again, we see courts who move cases more quickly, who have lower caseloads, paying more attention, and we don't see as much time between settings. It all comes down to that balance of how much time is necessary to get to the next step and allotting a reasonable amount of time for that, but no more than that. And then monitoring that, making sure people are aware you're looking at it. As long as it's reasonable, people can't argue with that. And I don't find a lot of pushback against the courts in that regard. But the other pieces of data we look at are trying to look for trends in different pieces of our caseload. And so we have seen a recent trend with an uptick in the number of DWI cases countywide. There are probably many reasons. I think the pandemic has contributed to that. That's, people are under stress, everything else. They're also not going into work every day. Many people are working from home, but are also out and about more often, so they're on the road more. Even though traffic is light for a commute, there's still a lot going on day to day out in the world. Other things, though, that are very important and that tie back to data, I think, are looking at how cases move. And when I say that, I mean, what are the things that lead to disposition, and trying to figure out which ones are most impactful, and looking at data to suggest that, getting down to the level of what was the last court action prior to disposition, and seeing if there are some events that lead to more dispositions than others. Can we move that up in the process potentially? Or what is it we have to get done to get to that event more timely? And so we're really just starting to look at things like that, but I think it's going to become important as we're facing backlogs. We are going to have to start addressing that and cutting into the backlog and doing something different with new cases moving forward is the only way we'll get there, or we'll just be creating the next generation of backlog.
Great, thank you. So looking to the future, to end on an optimistic note, hopefully, what do you think criminal courts are going to look like post-pandemic? What are some things that are upcoming? And what can we do now to prepare? And I pose this to Ed, Paul, and Brian.
Well, I am optimistic, actually. At some point this speedy trial is going to be turned back on. It's going to start to run, and there's going to be a lot of cases that need to be tried. However, the general feeling, I think, among court administrators and judges is there's going to be a massive crush and to have to trial those cases. I actually feel otherwise. I think we might feel that initially. And I think it would be wise to put judicial resources in the criminal division, even those judges that are not normally in the criminal division, perhaps those ones that are normally trying civil cases early on, as soon as things are completely open up, because as I mentioned before, the most serious cases are going to need to get tried. But I think that will go through quickly. I think that once we get to the point where we are routinely setting trials, we have judicial resources to try those cases, they're going to resolve. Because in every group, state attorney, public defender, they don't want to try every case either. It's generally, in most divisions, it's a small group of each. And I think ultimately they want to resolve those cases. So I think it's going to be a bump once we start going. But I see it will clear out before very long. Again, as long as you have the judicial resources, and that may be easier said than done, if you have the judicial resources available to try those cases.
Yeah, and I agree. I think once we are able to, on a regular basis, expose cases to real credible trial dates, yeah, there's going to be a crush of trials at the very outset. But once people figure out we're really going to go to trial, cases will start going away again. It'll take time to do that. I think judicial resources will become a big piece of that at the outset, but I think we'll work through that. The biggest thing I see in the future is all that we've learned in doing things virtually. How do we leverage and apply that to the future to make our courts more efficient? How can we utilize that to reduce the impact on working defendants and their appearances, right? And hopefully even reduce the incidence of non-appearance through the use of virtual hearings leading up to trial, not necessarily having virtual trials, but what proceedings can we do virtually in that initial stage of getting ready for trial? And so I think that's going to have a big impact on courts. I think we're going to learn more over the coming years as we embrace that technology even more. But beyond that, I think courts are just going to have to work through this. The reality is COVID, this pandemic has been our most recent and certainly different challenge that we've had to face. But other courts have faced the natural disasters that have impacted them and other things, political change, other things that go on. We still have to work to provide access to justice, access to courts, and staying centered on those principles at the end of the day is what will move cases the best. And when we're looking to the future, that's what we still have to be reminded of that. How we do our business may look different, but the core of why we do our business is still the same.
Right. I'd just like to echo some of those points that Ed and Paul just made. The idea of getting back to basics I think, is an important area of case management. It's an interesting spur to that has just happened with COVID, that it certainly knocked courts out of their complacency. If practice as it had been underway for years suddenly changed dramatically. And so courts, leaders, administrators thinking, how do we get our court back on a solid footing? And part of that is to pay attention to effective case management practices, as well as some new practices. Ed just mentioned that the continuation of remote hearings, for example, in certain situations. That is something that has been talked about for a long time, but was moving very slowly toward implementation. It just seems so different. Well, all of a sudden you're forced to do it, and it can work fairly well in some circumstances and is likely to continue. So if there's one sort of note of optimism out of all of this is to focus attention once again on case management and more efficient practices that not only resolve cases, but do so in a very fair and effective way.
Great. Thank you all. I know we have one more slide to show with our website. There we go. I just want to say thank you to Ed and Paul for joining us today. We really appreciate you coming with your words of wisdom. Thank you, Brian, for going through some of the highlights of the ECCM study. We have the website up here on the slide. I'll let Brian talk a little bit more about what you can find there.
Thank you. And thanks again, Ed and Paul, for this tremendous session. Really enjoyed your conversation. And as always, learn a lot listening to you guys. The ECCM project was a multi-year undertaking, and a number of products have come out of that. So if you are interested in learning more about what the data shows in terms of what influences and affects timely case disposition, there are several products on the website that you might want to check out. One having to do with timely justice in criminal cases, what the data tells us. I would recommend that. We also did work with 8 jurisdictions, and what we learned from those site visits and interactions with administrators and judges, we have summarized in another project called Success in Criminal Case Management Lessons from the Field that you may also find of interest. One of the big things about this was a massive data collection effort, and we are able to share some of that data in an interactive database that has a lot of information about felony and misdemeanor cases that you might find of some interest, and can come onto the website to explore that. So there are some, I think, some interesting products and information that support your efforts to improve timeliness in criminal case management.
And thank you everyone for tuning in to us today.